Today, uh, we are going to talk about, as I have just discussed, the relationship between law and society, the relationship between law and sociology, the relationship between legal thinking and scientific thinking. Right. Uh, Social science can be differentiated on the basis of their natures of study, on the basis of their subject of study, on the basis of their objectives of study, right? So law and society, can you guess, as far as your understanding is concerned, what could be the relationship between law and sociology? Hmm? See, first we have to know the meaning, right? What law offers in society? So sociology is also concerned with social order. Law also deals the social order. How? Law regulates our everyday life. Law regulates our marriage. Law regulates also breakup of marriage, custody of children, maintains equality in society, right? Law governs our businesses, environment. Law also governs our political life. Best and the most important task law does in society is law ensures peace in society. Law ensures progress in society. Just recall the idea of constitution. What constitution offers? Progress, prosperity, equality, justice, liberty. These ideas are actualized only with the intervention of law, right? Therefore, law is one of the important aspect of reality. And in coming semester, when you read legal methods, right, you will understand how law is made. What are the sources of law? Can constitution be the source of law? Can law passed by national and state legislature be a source of law? Can judgment pronounced by Supreme Court lawyers or High Court lawyers be a source of law? Can international conventions be a source of law? Yes, these are all important source of law. And law exists in society under particular legal system, which is known as operating machinery to govern the law. So when you understand the mechanism of law, that is to say the operating machinery by which law is governed, then you have to understand what are the roles of judges, what are the roles of lawyers, what are the roles of courts, what are the roles of media, what are the roles of society, right? So first thing you should understand is to understand the connection between rules or law of science or law of nature. Right? Because when we say rule of law, what does it mean? It means that our life is regulated under the very assumption of law, right? Law, how law is made, what are the process of legal thinking, right? What are the machineries by which law is governed, right? These are the very important questions, and you will understand in detail when you read legal method, right? And law itself is not capable to enforce. Law needs to be enforced. Therefore, state authorities is very significant, because law needs to be enforced by the state authority acting under the power conferred on them by law, right? So, and what is the role of law in society? Because once you understand the role of law in society, then you can understand the interrelationship between law and sociology. Law is closely linked with the society. I would say the deeply, linked with society. As society develops, law also develops. Law goes on changing with the changes in society, right? I can give one illustration of changes of law in society. Suppose once upon a time in India, homosexuality was crime, but with the rationalization of society, this idea of sexuality has changed. Subsequently, law has changed. So homosexuality is new normal in society, right? Now, homosexuality is not considered to be a crime, right? So this is the dynamics of law, right? Law also changes, right? So we have a huge number of amendment in the Constitution of India, right? And law is very important reality which makes it which gives a sense of normal, right? So what is normal and what is abnormal in society, this distinction is made by law, right? Suppose now homosexuality is a normal thing. Why? Because law guarantees this fact, this aspect. right? So law is one of the significant aspects which determines or which distinguishes between normal and abnormal. In other words, law is effective tool to lay down norms in an area, and the members of society are expected to adhere those norms. It is in the interest of society and adhere to the norm led by the law, right? So there is a interconnection between law and society, or in other words, a state and society, right? The state is one of the manifested reality. Law is a manifested reality of a state. A state speaks in the language of law, right? And society has to follow the law, right? And you will understand in legal method like how law is made. Law is made by bylaws, rules, order, statute, ordinance, and even some societal values as well, right? Suppose in India, Quran, as far as the Muslim law is concerned, Quran plays a very significant role, right? So sometimes norms, religious norms also plays a very significant role, right? Some laws are meant for all, but some laws are specific because Constitution of India celebrates diversity, right? So there is some differences in terms of law. Although we are talking about universal civil code, but this is not achievable, right? Because we have a huge number of diversity, right? And law also spells in the language of culture, right? So all the minorities law which deals with minorities affairs, particularly the civic affairs, marriage related thing, right? Their law connotes the reality of, you know, culture, right? So we'll talk about the evolution of law, right? How law changed the nature in second semester when I will teach you Henry Mann, right? And in previous time or in old days, religion was the all source of law. Therefore, custom is the oldest source of law. Before the advent of any legislation or precedents, custom was the most important source of law. Even nowadays, in tribal society or in a simple society, agrarian society, custom plays a very significant role in terms of the legal affairs of the society, right? So we have to understand the very interconnection between law and the society. And when we try to understand law, particularly after modernization, right? Again, I can give you a sense of modernization or the advent of modernization with the advent of French Revolution, Industrial Revolution, and Enlightenment movement. There is a thinker called Oliver Winden Holman, Holmes. He said that the law embodied the story of nations' development through many centuries. Right? Every legal system stands in a close relationship with ideas, aims, and the purpose of the society. Right? So, when you see legal system of any country, you can understand the relationship of ideas, aim, and the purpose of the society. So law is made for the society, right? And law reflects a kind of intellectual, social, and economic political climate of its time, right? If you want to understand colonial time, just see the law and the nature of a law which discriminated Indians, which discriminated blacks in the context of America, right? So law itself spells a situation of society. So if you have a democratic society, you will have democratic law. If you have humanitarian society, you will have humanitarian law, right? And therefore we can say law is inseparable from the interest, from the goals, from the understanding that deeply shaped or compromise social and economic life of a society, right? When we try to understand the interrelationship between sociology and law in the academic discipline of sociology, the study of law embraces a number of well-established area of relevant inquiry. In sociology, there is a field called sociology of law, which deals with the very nature of law or the relationship of law and the society. Both sociology and law are concerned with the nature of legitimate authority, the definition of relationship, mechanisms of social control, how social order is maintained, sustained, and attained through the intervention of law, that is the mechanism of social control, issues of human rights, power arrangements, the interrelationship between public and the private spheres. So these are the important areas where law and sociology come in a same platform, right? And both sociologists and lawyers are aware about the behavior of judges, criminals, litigants, customers, right? And I can recall one thinker called E. Ross, E-R-O-S-S, who said, and he considered law as the most specialized and highly furnished engine of control employed in the society. Highly furnished engine to control employed in the society. Therefore, law is very significant. because law tells you how to govern the life. How, who can govern the society? Law tells you. Who has authority of social planning for the betterment of society? Law identifies. And law punishes as well, for the sake of social control, for the sake of social order. Right? In sociology, there is a man called Roscoe Pond, and he gave a very insightful understanding of law. And he said, law was a specialized form of social control that exerts pressure upon a person. Right? You have always, a kind of fear, if you a kind of deterrent, right? If you do bad, you will be punished under law, right? So it exerts a pressure upon person in order to contain him, to do his part of upholding civilized life, right? And to deter him for anti-social conduct, that is the conduct at variance with the postulates of social order, right? So law gives a sense of upholding civilized life. How you are, right? And it gives deterrence. Deterrent का मतलब fear, not to do anti-social conduct, right? Therefore, law as a reality exists, and we have to understand and underline the fact that law is a very significant reality in modern society, right? So, is there any distinction between the profession of social scientists and the profession of lawyers? Yes, both have a scholarship, both have thinking of social order, but both have different language, different approach. I can recall one thinker called Edmund M. Schuller, and he correctly noted that in a sense, lawyers and sociologists don't talk in same language. And this lack of communication undoubtedly breeds uncertainty in both professions concerning any involvement in others' domain, much less any cooperative interdisciplinary endeavor. And he adds that sociologists and lawyers are engaged in quite different sorts of enterprises, and noted that the lawyer's characteristic need to be make decision and here and now may reminder him impatient with the sociologist apparently unlimited willingness to suspend final judgment on the issues, right? So many thinkers tried to distinguish profession of a lawyer, characteristics of a lawyer from that of the characteristics of sociologist, right? Or the, in other words, social scientist, right? But both are concerned with the solution of social problem. Both are concerned with the solution of crime, right? But sociologists emphasize more on creativity, theoretical imagination, research ingenuity, right? And lawyers has different things. Lawyers interpret the law, right? Contextualize the law, right? So there was a thinker called Wilhelm Auderet, Vilhelm Aubert, and he explained that there are some uh, differences in thinking of lawyer and thinking of social scientist, or in other words, the thinking of legal thinking and uh, uh, social science thinking or scientific thinking. First, he identified that law seems to be more inclined towards a particular than towards general, right? So when you read any law, you have particular case, right? What happened in a specific case, right? Suppose you want to understand the issue of child labor, right? So there is a particular case, right? फलाना versus फलाना का केस है वहां, and you can understand with particular case. So it means like the statement said by Audred that law seems to be more inclined towards a particular than towards general seems to be right. Law is, unlike physical and social science, does not endeavor to establish a dramatic connection between means and end, right? Suppose, for example, the impact of verdict, right? The impact of the verdict has on the defender's future conduct, right? Law does not acknowledge the fact, right? Suppose a criminal got imprisonment, right? So law does not take care about his or her future, right? He law concerned with the present, right? Law concerned with justification, right? Law does not concern with explanation, right? So law does not take account of the impact of the verdict has to be the defender's future conduct, right? But scientific thinking or social scientific thinking acknowledged the futuristic aspect of reality, right? So in other words, law is a kind of present oriented reality, and social science also incorporates the future orientation, right? Third important point is truth for law is normative or non-problematic. Either something has happened or it has not. A law is either a valid or invalid, right? For example, did a person break a law or not, right? So this is so truth is always normative, right? Here law is primarily past and present oriented, as I have just discussed, right? And rarely concerned about future events. For example, as I have just said, what happens to the criminal in future? Law does not take this account, right? So when you use legal thinking, right, you must concern about the fact that law is primarily past oriented, primarily present oriented, and rarely concerned with the future oriented events. Legal consequences may be valid even they do not occur. That is, their formal validity does not inevitably depend on compliance, right? For example, the duty is to be fulfilled in contract, and if it is not fulfilled, it does not falsify the law in question, right? Last important point he discussed is a legal decision is either or all or nothing process with little room for compromise solution, right? For example, litigant either wins or lose in a case. There is no scope of you know compromise, right? Compromise. So these are the very important distinction, right? And I will send this note today all. Uh, and you will again read and please try to grasp that what is the scope of legal thinking or limitation of legal thinking, right? Scientific thinking is different, social scientific thinking is different from legal thinking, right? As there is although social order is the ultimate question of law and social science, social progress is the ultimate question, but there is a difference, right? And you have to identify the difference, right? And in next class we are again going to talk about in detail the uh, definition of law, and then after we are going to talk about some of the very important